Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam. I'm your host, Anora Wang. Competition laws and enforcement regimes are being developed around the world, some with shorter histories but rich opportunities for exploration, including how the agencies can be designed, how they function, and how they prioritize their enforcement given the particular competition concerns in those jurisdictions. Hong Kong provides a great observational point, where the competition laws and authority are relatively new and recent, but we see enforcement in entrepreneurial and sometimes innovative ways. And it would be a service to our listeners to learn a bit directly from the enforcers there. Joining me today is Chairman Samuel Chan of the Hong Kong Competition Commission, or briefly, we just call it HKCC, who is a practicing barrister and has been appointed to many advisory and statutory bodies within Hong Kong. Before joining the HKCC, Chairman Chen was former Vice Chairman of the Consumer Council, Non-Executive Director of the Insurance Authority, member of the Equal Opportunities Commission, Chairman of the Consumer Legal Action Fund Management Committee, and a Deputy Chairman of the Town Planning Appeal Board. Currently, Chairman Chen also serves as a member of the Operations Review Committee of the Independent Commission Against Corruption and member of the Working Group on Class Actions. Outside of his role at the HKCC and the other roles that I've just mentioned, Chairman Chen maintains his legal practice as a barrister and as an arbitrator. He's a fellow of the Chartered Institute of Arbitrators, a fellow of the Hong Kong Institute of Arbitrators, and a panel arbitrator of the Shenzhen Court of International Arbitration. Welcome to the OCA program, Chairman Chen.
Thank you, Nora, for having me.
Our pleasure, Chairman Chen. Before we go to the several questions that we discussed, and we're going to go into a little depth there, could you give us a high-level introduction of your agency, namely, what does it do?
Well, sure. HKCC enforces Hong Kong's competition ordinance, which basically is modeled on the EU model. We have the three pillars, cartel conduct, abuse of dominance, as well as the merger rule. And the merger rule applies not cross-sector, but only against the telecom sector for the time being. And there are 15 members of the board. All of us are appointed by the government. We are not full-time members or commissions as such, because there is a full-time executive arm, which will take care of the day-to-day operation. But the decision-making body is the commission collectively, the 15 members, including me as chair.
Just that is a little bit surprising to our listeners, I think. So, Chairman Chen, what is the HKCC's top enforcement priority, or even plural, top priorities for the rest of 2024?
Well, thank you, Nora, because it's somewhat difficult for me to say which is the top enforcement priority at any time. But in 2021, when we marked our 6th anniversary of the full commencement of the competition ordinance, we made it quite clear and we announced openly that there are 3 enforcement priority areas for us, which is first cartel behavior, which affects people's livelihood, especially the low-income group. And secondly, anti-competitive conduct, which seeks to exploit government subsidy. And finally, digital economy. So those 3 areas are what we regard as our enforcement priorities.
And you mentioned that was first raised in 2021. Are those 3 top priorities remain today in 2024?
Oh yes, because we marked our 6th anniversary in December 2021. So we're talking about less than 3 years by then. So for the time being, or in the foreseeable future, we are still continuing with these 3 enforcement priority areas.
And HKCC is not such a big agency in terms of resources and staff members, right? So I guess with the 3 top priorities, or you're not seeing a need to shift or maybe rank, I guess, the priorities of enforcement.
Perhaps it has little to do with our headcount as such, but rather the rationale behind setting these 3 enforcement priorities is to make sure that our work and operation will be relevant or even highly relevant to the lives of the people in Hong Kong, because HKCC, as you mentioned, is a relatively new agency. And so we just want to make sure that people in Hong Kong will buy in to this, the creation of this new regime of competition law in Hong Kong.
Yeah.
So we have to make sure that what we do will be relevant to the daily lives of the people.
Which makes great sense. So while you're at HKCC, I think you're also collaborating with enforcers in some other jurisdictions, some neighboring jurisdictions, right? Like, Japan, the mainland China, and also maybe other areas, and even like, beyond US, EU. In these interactions, I'm sure you have great observations as well. What would you say is the most important trend that you see developing in competition law enforcement in the near term?
Right. I think if we are talking about the global competition policy community, obviously AI, sustainability will be the talk of town in the foreseeable future. But in a Hong Kong context, I would have thought that further collaboration between HKCC and other law enforcement agencies will be our focus. For the simple reason that, as you mentioned, because of the size of HKCC, we need to tap on the resources of other law enforcement agencies for intelligence, for manpower, to carry out dawn raids, for data entries, raw data, for data screening purposes, in order to detect questionable behavior. So collaboration with other law enforcement agencies will be, I think, a unique feature in the case of HKCC.
That also makes great sense. Has HKCC done a dawn raid yet?
We have done quite a few. Okay. And when I say collaboration with other law enforcement agencies, we actually carry out joint operations together with the police, with Immigration Department, and with ICAC, which is the Independent Commission Against Corruption, which is the anti-corruption agency in Hong Kong. And we have seen a lot of benefits by collaborating with these law enforcement agencies. As you can tell, because sometimes when we carry these dawn raids, we are trying to crack down activities of triad societies, organized criminal syndicates. So it could pose certain risks to our colleagues. So it is important for us to be able to obtain some assistance and support from other relevant law enforcement agencies like the police.
Shift gear a little bit. So you're the chairman of the agency, and you have practitioners, I think, including Hong Kong practitioners, maybe foreign practitioners as well, before you. Do you have any advice for them so that they can be more effective in front of your agency?
Well, that's a very interesting question. The advice I would give is perhaps not to be overly aggressive or antagonistic with us, because, well, as a barrister who has practiced for almost 35 years by now, I can well understand that to a lot of lawyers, litigation lawyers, sometimes they think litigation is like a boxing ring. And maybe sometimes they want to impress their client. But my advice is it doesn't make sense for practitioners to be too aggressive with us, because it may backfire at the end of the day. You may not be able to secure the best result for your client in terms of reaching a settlement or in terms of getting an amount of pecuniary penalty which is acceptable to your client. So I think we'll be sensible.
It's a good advice for general practice as well. So I actually only have one more question, but before that, I really want to mention this because I picked this up, this interesting fact from a panel that you did at the spring meeting with the ABA in April 2024, which is that HKCC produced these like interesting cartoon or short videos.
Short videos. And on top of the short videos, if you go to our website, you just click on publicity tab and and you can find the links to all these short videos or TV ads or TV commercials that we have produced. But more recently, we have produced, with the assistance of one of the Hong Kong TV stations, what we call a docudrama, which is a 5-episode docudrama.
Yeah.
And actually the scripts are based on real cases that we have handled. And the episodes were shooted in our office, in a real office.
Okay.
And so it's quite popular and it's very effective in our public efficacy work.
Okay. And you have like award-winning or at least not like award-nominated actor and actresses playing, I don't know.
Well, the main actress is nominated for the best actress in Hong Kong Film Awards.
Yeah.
I think the results will be announced pretty soon.
Did they do this pro bono? Did they?
Not pro bono, but I would say with a very reasonable fee.
That's very
because after all,
interesting.
this is sort of a public campaign.
Yeah. I'm sure that has been a very popular and effective way of educating the public about the competition law and your enforcement agency. And just shift gear to our final question, and because our listeners are always interested in learning about the guest speakers a bit more as a person. So would you care to share with us, do you have any interesting hobbies or accomplishments outside of competition law?
Okay, well, I like to travel. I travel a lot. Well, at the risk of being slightly presumptuous, I think I'm pretty well traveled. And I love to travel with my family, and we've been to quite a number of places around the world.
Yeah. Are there any places on your list that you have not, been able to travel to?
Perhaps Antarctica.
That would be a difficult one to make.
That would be a difficult one, and I don't have any plans to do that.
Not in the near future.
Not in the near future.
Yeah, who would know? Thank you for speaking at OCA. It's a great pleasure.
Thank you, Anora.
On a global scale, some of the most important economies are outside of the US and EU, but our listeners may have been less familiar with the competition laws and enforcement in those jurisdictions. Japan is a great example, where you find one of the longest existing competition authority in the world. Joining me today is Commissioner Reiko Aoki, who is an economist and who has actually obtained a PhD, and I want to make sure I mention that, and a commissioner of the Japan Fair Trade Commission since 2016. Before joining the JFTC, Commissioner Aoki has served as Executive Member of Council for Science and Technology Policy of the Japanese Cabinet Office from 2009 to 2014, and a member of the Information and Communication Council, as well as a member of the Science Council of Japan from 2014 to 2016. Aside from being a public official, Commissioner Aoki is also a scholar and has conducted research and published on economics of patents, patent pools, standards, innovation, and intergenerational political economy in academic positions at Ohio State University, SUNY Stony Brook, University of Auckland, and Hitotsubashi University. Commissioner Aoki was also once the executive vice president at the Kyushu University. Welcome to the OCA program, Commissioner Aoki.
Thanks for having me.
Our pleasure, Commissioner Aoki. Before we go to the several questions that we will discuss about your agency's enforcement, could you give us just a high-level introduction of your agency?
Sure. We're an independent agency that enforces the Japanese Anti-Monopoly Act, which was enacted in 1947, and currently we're about 900 employees strong.
That's great. What is JFTC's top enforcement priority for the ongoing year, which is 2024, and maybe next year, 2025?
Priority is set on the digital market in recent years, and like many other countries, Japan has been experiencing rapid and global changes in the society and the economy. And in particular, digitalization is advancing with increased speed, and we need to address competition-related issues very swiftly. And in October 23, we launched an investigation concerning Google's suspected antitrust violation related to search applications, on Android devices. This investigation targets not only pre-installation of Google's applications on Android devices, but also the revenue-sharing contracts between Google and device manufacturers. Based on the contracts, Google allegedly distributes its earnings to device manufacturers on the condition that they do not include competitor search apps on their devices. The conduct of big techs in the digital sector has far-reaching effects on individuals and companies. And also the competition in the search service has entered a new phase with the advent of generative AI. Therefore, we officially announced the launch of the investigation and solicited information and opinions from various stakeholders regarding the competitive impact of Google's conduct on the Japanese market. Along with enforcement, competition advocacy is a useful option to address the digital competition issues. We issued a market study on mobile OS and mobile app distribution last year, 2023. This report contains a proposal for developing a new regulatory framework beyond the existing competition laws, including ex-ante regulation. The report indicated that conducts that could violate the Anti-Monopoly Act, such as self-preferencing, while the market of mobile OS and app stores are duopolized by Apple and Google with limited competitive pressure. However, enforcement of the AMA, the Anti-Monopoly Act, may take considerable time because of complex market definition and proofs of harm. To overcome those challenges for the enforcement in the complex and fast-moving digital market, we need some new tools to effectively prevent and correct anti-competitive conduct by creating a level playing field for third-party apps and app stores. Based on the JFTC's proposal, the Cabinet Secretariat of the Japanese government published a final report on a competition assessment of how the layered structure in the mobile ecosystem affects the competitive environment. The final report recommended introduction of ex-ante regulation framework. Based on the approaches outlined in this report, the JFTC is currently considering the legal framework necessary to ensure a fair and equitable competition environment in the mobile ecosystem. And bill is now under consideration. We have a very optimistic view of what will happen. And I think this also demonstrates how JFTC works with the rest of the Japanese government to guarantee a competitive environment in general. And in addition to digital cases, we're also addressing anti-competitive conduct in other sectors. For instance, we imposed a record-breaking amount of surcharge in a cartel case by regional electric utilities. These firms were previously granted legal monopolies in the specific regions. Following deregulation, each regional electric utility company has become able to expand its business into other territories which had been dominated by other local monopoly utility firms. However, they colluded not to actively solicit customers in other territories and then restricted competition in the electricity market. Though this case gained attention due to the high surcharges, this case is also significant in the context of deregulation. The JFTC sent a clear message that we strongly support industrial deregulation from the perspective of competition law and enforcement. While digital sector is important in our enforcement, we also continue to engage in traditional cartel cases, as this utility case demonstrates, and this will continue for the coming years.
Thank you for that very informative and thorough answer, Commissioner Aoki. I'm sure you are also in collaboration with a lot of other enforcers around the world, and in doing so, you may have observed some important trends. So would you share with us what in your view is the most important trend that you see that's developing in competition law enforcement in the near term?
We are currently facing new social challenges stemming from digitalization, and competition authorities need to address these challenges by maximizing what we have and its potential, and also developing new legal tools. For example, the advent of gig economy has enabled more people to freelance or become solo self-employed workers. Mm-hmm. However, these individuals are considered undertakings rather than employees, so they're not covered by labor law. Mm. There was a public demand to ensure fair treatment of these freelance workers, so the Japanese government decided to submit the Freelance Protection Act to the legislative body, and this regulation was approved 2023. The JFTC will play a crucial role in ensuring a fair trading environment surrounding freelance workers. In addition, as mentioned earlier, the JFTC is now considering the new regulation on the mobile ecosystem. Mm-hmm. Let me briefly introduce 3 elements of this bill under consideration, which can be considered a Japanese version of the DMA. First of all, the JFTC will designate operators of the mobile operating systems, app stores, browsers, and search engines that are larger than a certain size, very similar to the European DMA gatekeeper concept. Mm-hmm. Secondly, it stipulates prohibitions against certain anti-competitive conducts and obligations to take certain measures to comply with the new regulation for designated operators. We are considering such as requiring the effective use of alternative distribution channels for apps that ensure security and privacy. And last but not least, it will also stipulate enforcement procedures, including cease and desist orders and surcharge payment orders against violators to ensure the effectiveness of the new regulation. This bill is yet to be finalized at this moment, but we have a very optimistic outlook. If the regulation is acted, we can get the power to create a level playing field for the third-party apps and app stores in the mobile ecosystem. These examples show the extent that our mission is expanding. Mm-hmm. The new legal tools will bring us the further power to respond to public demands and carry out our mission. We are now engaged in dialogue with stakeholders to carefully prepare these tools in details. By smoothly implementing these rules, we'll surely be able to deliver the benefits to the public.
Thank you for sharing your observations. But if you want to help the practitioners who make up a significant portion of our listeners a little bit more, what advice you would give for them, including international and Japanese practitioners who may be in front of your agency? How can they be more effective?
My advice is to come to us at an early stage if you have any concerns. Let me show you, as an example, our efforts regarding sustainability and green society. We have worked on antitrust and sustainability for decades. Most recently, we issued the Green Guidelines in March 2023. The guidelines provide a comprehensive guidance on initiatives regarding greenhouse gas reduction and the competition law, with as many as 76 hypothetical cases. In addition to issuing the guidelines, we advise the companies to come to us for consultation. If a company has not yet initiated a business plan, we are open to consultation and provide advice based on the green guidelines if they have any doubts or anxieties about its competitive effects. We have already received some consultations on specific green initiatives. One example of such a consultation is of joint activities for carbon neutrality by enterprises of petrochemical complex, which is published February 2024. The JFTC examined the case that was consulted and concluded that the joint activities would not cause substantial restraint of competition in any particular field of the trade. This conclusion was based on the existence of competitive pressure from competitors and users. The firms were able to proceed with their plan, and the JFTC also published the result of this consultation with the parties' consent for the rest of other companies who may be contemplating a similar initiative. As you can see from this example, the JFTC is open for consultation from companies on their business plans, and we offer consultations not only for green initiatives, but also for other fields. So again, if you have any concerns about your business plan, please come to us at an early stage. And also, as we saw with the Google case, we're always keen to hear from all the stakeholders related to the any market, particularly digital markets, where there are very new disruptors and also newly disadvantaged incumbents because of the changing environment. And we're very keen to hear directly from them what's going around, what is happening to them, and any concerns that they may have.
These are all very helpful. While we're here, and let's shift gear for a little bit, we want to take advantage of the opportunity that we have you here. We want to let our listeners to have a chance to learn a bit more about you as a person. Would you share with us if there are any interesting hobbies or accomplishments, I would say outside of competition law, that you would care to mention and share with us?
Okay, my major accomplishment would be I have 2 grown children who are very healthy and happy. I can't claim all the credit. My spouse, my husband, has been very cooperative, but that's a major accomplishment I'm very proud of. In terms of hobbies, I anticipated this question, so I give it some thought. And I can't think of any hobbies off the top of my head. But one thing that I did do COVID, where I think many people picked up a hobby, was I learned a new computer programming language, Python.
Wow.
And I didn't think I would learn another language at this age. But Python would be my 5th computer language.
Yeah.
And it shows my age, and I can really appreciate how the technology has changed, because the first computer language I learned was called assembler, that I learned as an undergraduate in the 1970s. And assembler is a machine language, which you probably never heard of, Anora.
I confess I haven't heard of
because
it.
It's a machine language where you have to actually know what the registers are doing, and there's no compiler. So that was in the 1970s. And then in the 1980s, during my master's program, I learned Fortran and BASIC, which are more
that
friendly.
I have heard of.
Yeah, you heard of. Yeah.
In some reference to historical
language. And still, Fortran was very tedious.
Right.
So that was in the early 80s. And then when I went to Stanford to do my graduate work, they had an introductory course on computer language, and the language I learned there was called Pascal. And compared to assembler or BASIC, it was a vast improvement. It was so much easier. One thing that had changed was that they stressed ability for others to read your program and understand what's going on, compared to what they stressed before, which was parsimony, because computation took so much time, right? But with Pascal, the computer had advanced enough, the computer speed had advanced enough that it was important to have the computer language written in a way that people understand what you're doing.
Wow.
And so I thought I would never learn another language, but in 2022 I was supposed to learn Python, and I had heard Python was very good with letters. And it was true. It handles strings much better than Pascal.
The previous,
Again, I appreciate advancement in computer power.
What do you use Python for? What are you coding?
It's just a hobby.
Just a hobby,
yeah,
huh?
So, but I wrote the Hangman program, which was part of the course.
Wow. Wow.
I really enjoyed it.
I would still put that in the achievement category, but to you, it's just hobby.
Yeah, because I have no use for it. So it is hobby.
Very impressive, and our pleasure to talk to you.
Thank you.
Thank you.
Anora.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.